or at the applicant.
Huh?
Inclusion of the application.
All will be included. Why are you mentioning?
So that it was in the list. Earlier it was in the list. I mean, I'm paid for accommodation for lordship. Your lordship allowed accommodation, but on 21st November. But in the meantime, earlier that came up, and we could not follow it. Therefore, resulting in we have to file a restoration application. Restoration application allowed on 17th. But our lordship didn't send it on 19th. It will appear. It will not appear.
It will appear after vacation.
And make it. Thank you.
Inclusion in the next matter, bill in connection with that.
After vacation.
I'm gonna leave to move before the vacation.
No, we will hear you. Let us hear you. Let us hear you. Tomorrow this is going to be listed. Don't worry. Don't disturb a vacation bench unnecessarily. No leave is granted. File it.
I am disturbing. Again, I am some matters I could not.
Matters are on the list, Mr. Public Prosecutor. We will deal with them on their merits. If we find that the case diary is necessary, we post it after vacation. If we find that it's not, we will deal with it so that everyone gets an opportunity of moving his matter. If he has filed it, he will get an opportunity of moving his matter. What order we will pass, we cannot assure. But what we will give you a hearing. Every matter will be given a hearing.
I'm only bothered that your lordship proceedings is not hampered because of non-production.
No, but
not getting questions for us time.
no difficulty. At least have someone. Mr. Noli is there. Miss God is there. So let them tell us that if the case diary is not there, we will ensure. If we see the FIR, if necessary, we'll give an order, protection order, and place it after vacation. Call the list.
Lordship, leave may be granted before the file before the regular bench with two separate rejection orders. 6 petitioners, 4 in one order, 2 in other order.
Leave is granted. Leave is granted. Call the list.
But I am for the appeal.
But I have been,
I am for that.
but I am in item number 3.
Yes, someone is ill.
Your lordship directed
Sir, I have a report that was called for
Sheikh Babu. Who is in appellate number 1?
I'm for that.
You are for 1. Let us see.
But your lordship called for your
Report,
lordship heard the
report.
matter on
Yes.
22nd of November concerning the health
Correct.
condition of the appellant. Your lordship called for a report. He was in Bardhaman Hospital. His health condition having deteriorated, he was transferred to SSKM. And there his health condition is deteriorating further. Your lordship called for a report.
Okay.
My lord had occasion to grant interim bail to one of the accused. However, he did not survive.
Reduce the medical report. Appellant is suffering from cardiac ailments and has been in treatment since is suffering from cardiac ailments and has been in treatment since 2024. Presently, his health condition has deteriorated and he had attended and he was treated at Nephrology OPD SSKM Hospital and Bhangur Institute of Neuromedicine and Cardiology. OPD, Nephrology and Cardiology SSKM Hospital and Bhangur Institute of in light of the aforesaid health condition of the petition of the appellant and purely on humanitarian considerations to enable the appellant to avail to avail better medical treatment, we enlarge the appellant on interim bail. Appellant shall be released on interim bail till 28th of February 2025 or until further orders, whichever is earlier, on conditions so and so. Matter will appear on 20th February 2025.
Thank you.
Appellant shall present himself before the Superintendent SSKM Hospital on 10th February 2025 for for assessment of his health condition. Superintendent SSKM Hospital shall submit report to this court on the adjourned date. All
Thank
right.
you.
So 10th you will appear before the superintendent. There will be a assessment, whatever. They will give a report on 20th, and interim bail is continuing till 28th.
Thank you.
Next. Check a report with regard to death certificate has been
I have the death certificate.
filed. In light of the report, the appeal abates so far as appellant number 1, Sheikh Shahjahan, is concerned. Next. Yeah, Mr. Basu, the legal representatives propose to proceed with the appeal.
Let me take information.
All right, notice be issued upon the
Relations of-
legal representatives of the deceased appellant, intimating them of their right to substitute themselves in place of the appellant. 28th, report department shall issue the notice.
28th of January.
Can you give the names of the legal representatives so that notice can be given?
Right now, blood, I cannot ship, but I will collect it.
Then you
I also will collect it.
just notice করুন কার উপর দেবে সব একসাথে হঠাৎ নেক্সট 5
In 5, I'm praying for correction of any mistake of a petitioner. Number 2 of inadvertent typographical mistake, my lord.
petition number 2, what do you want?
It is 40, my lord. It's CHA instead of
All right, liberty to correct the cause title of the petition and change the name of petitioner number 2 as 40 in place of 40. Spelling, please give the spelling. Other part. Next.
If I am praying for adjournment, kindly please take our notification because we have said for the verification of this gift deed, which has been annexed with this petition.
Rashid, my mother gave me a plot of land by way of registered deed in 2020. Subsequently, I sold that land to one Paresh Chandra Bishwas. But then later on, I came to know the land mother gave me, it is a co-sharer, some portion was encroached. I immediately returned 9 lakhs by way of bank transfer to Paresh Chandra Bishwas.
Fortunately, is not the complaint here.
But later on, I find one of my co-sharer, Nupur Nandi, she filed a case against me. But when I came to know that my mother made a mistake in co-sharer property, I immediately returned
Alright.
9 lakhs.
Petitioner's mother had gifted joint property in her favor, a portion of the joint property in her favor. It is a co-sharer has claimed right, title, and interest on the property.
From the record, there is no sign of the joint sharer or co-sharer as the mother of the petitioner. Kindly see the
If
record.
a registered deed has been
Well,
executed,
that is why Mala, we have to
if a
verify.
registered deed is executed, you have to cancel that deed. It will not create right, but it is clouding the title of a third party. That is not the subject matter of a criminal case. You have to file a declaratory suit.
But the petitioner has signed several deeds with the several persons, brother. So this is not a case of
But
one-
those several persons have not approached this court.
one.
A co-sharer claiming title has approached.
He is not the co-sharer. Who is the defective?
The owner has কি বললাম? Interest on the property. He prays for anticipatory bail. Learned lawyer for state contents. Petitioner's mother had no right, title, or interest in the property. The de facto complainant is the owner of the property. Through a fraudulent deed, petitioner claimed ownership over the property and has purportedly entered into sale agreement with a number of persons. Being aggrieved, the owner has lodged the criminal case. We have considered the materials on record. A gift deed was registered in favor of the petitioner in respect of the property in question. Her mother had gifted the property. It is open to the complainant to seek cancellation of the gift deed. In the event, the petitioner cancellation of the deed in accordance with law. None of the purchasers have lodged complaint against the petitioner. Claim of the against the petitioner. In this backdrop, we are of the opinion custodial interrogation for progress of investigation is not necessary, but petitioner requests to cooperate with investigation. 10,000 two sureties meet investigating officer. Next. Declaration.
Yes, Lordship, my application.
Nine.
Lordship, the case under section 302 of the Indian Penal Code. Lordship, charges submitted, Lordship. Kindly come to my involvement, Lordship.
All involvement are there. My involvement.
164 statement.
What is the 164 statement?
No, I witnessed was there, Lordship.
164 page 62.
Yes.
That is the statement of the wife of the deceased. wherein she has stated regarding the previous enmity and previous threat by this present petitioner along with the other.
Charge sheet filed.
Charge sheet has been filed, warrant of arrest has been.
So how charge sheet is filed on this? Charge sheet is filed.
No. There is a CDR matching mallet of these three persons, this present petitioner and the deceased
Hmm.
in that locality where the incident happened. As per the state.
Petitioner contends he has been falsely implicated out of mere suspicion. He prays for anticipatory bail, and a lawyer for the state opposed the prayer. We have considered the materials on record. Statement of the petitioner's deceased wife disclose enmity between the petitioner and the deceased. On the fateful night, deceased had been murdered. CDRs show close proximity between the petitioner and the place where the deceased was and the place of occurrence. In view of the aforesaid materials, we are of the opinion this is not a fit case to grant and strictly bail. Aforesaid materials and gravity of offense. Next.
Allegations are under section, my lord, 448.
Initially, he was admitted at wherein the.
My lord, I am 74 years old, my
You
lord.
are 74. Let us see how much injury he suffered.
And my lord, principal accused who
We have
blow?
heard you. Let us first see the nature of the injury.
It's a grievous.
Mohammed is already arrested. আচ্ছা আচ্ছা বলো
All right. We have
বলো তোমার যা
considered
ইচ্ছা
petitioner is a septuagenarian. We have considered the medical papers. It is contended he is not the principal. Is he principal accused?
No, no.
He is not the principal accused. Accordingly, we are inclined to grant answer. Next.
কাগজগুলো কই আমার সম্পত্তিগুলো? এই আমার সম্পত্তি।
Sir, defect to the vision.
Rampur 17 Yes. Yes.
May it please this court. Madam, there is a nursing home by the name of Asta Nursing Home. This Asta Nursing Home was under the control of one Anando Datta. My daughter got admission into that nursing home. Subsequently, she passed out also. A relationship grew between the families of Anando Datta and my husband and myself. Subsequently, the relationship went sour. Now, this Anando Datta happens to be a very influential person of the area.
Nursing home is owned by Ananda Datta.
He under his control.
Who is the owner? Whatever. So Ananda Datta is running the nursing. Your daughter?
It's a nursing college.
Acha, nursing college.
My daughter got admission over there by paying
Money.
Then there was a relationship between the families. The relationship went sour. Subsequently, this Ananda Datta lost the first case, where he says that he paid me 8 lakh rupees to get a MR dealership. We showed this honorable court the documents which have all been annexed, that there was a monetary relationship between the parties. And yes, it's true that I still owe him 2 lakhs. On the basis of the continuous monetary transactions, this honorable court was pleased to grant me anticipatory bail, me and my brother. Now, over the same self-incident of assault, one of his friends lodges another case.
No, assault. When does assault take place? In relation to this monetary transaction?
An assault also took
skirmish.
place. Skirmish took place in the first FIR also. Skirmish is mentioned. In this FIR also, skirmish is mentioned. Now, the skirmish took place. It is in the first FIR. There is no this thing with regard to this particular lady, Ruposhi Chatterjee, being at the place of occurrence. Who is the de facto complaint? For the same self-allegations, she lodges another FIR. Before your lordships, that is item number 12. And Mara, the order granting anticipatory bail is at page 237.
She's getting the FIR 11th October.
Now, the facts, the date of occurrence and place of occurrence.
The date is tinkered by 1 day.
So it is a different day.
But Marad will kindly appreciate that if he was assaulted on the 11th, then again he wouldn't have gone on the 13th to get assaulted again.
Who was assaulted on the 11th?
Ananda Datta claims to have been assaulted.
That is the 1595 FIR.
Yes.
1595. What is the gist of the 1595 FIR?
Your lordships will get it at page 236.
Yes, and present FIR?
Present FIR, your lordships will get at page 244. Please wait.
In the earlier FIR, the incident is of 13th,
13,
and here it is 11th.
11. Now, my lord, if on 11th he had got assaulted, then he wouldn't have gone back on the 13th. And on 13th, he had assaulted us. We had gone to the hospital. My lord, the medical records are there. And lordships, the entire incident is at page 252. My lord, the GD entry that we had lodged. My lord, the type copy is at page 252A.
This is the 13th October incident.
30th October.
So according to you, the 11th October incident is a fictitious one. 13th October, there was an exchange. You
Skirmish
say that
was there.
13th, Anando, an unknown lady came and you opened the door, you were assaulted. That's your case of 13th.
For which I have been granted anticipatory bail by this honorable court.
Let's see. This is one of the cases.
One of the
And
cases.
the other case?
My lord, the second case, item number 13.
13th other.
13 निकाल लो। My lord, he was introduced to us. My lord, he is a interior designer. He was introduced to us by the petitioner.
Where is the FIR?
My lord, the FIR is at page 242.
41.
My lord, in this one, it will be, my lord, the page will be 291.
291.
I am for the victim in this.
We'll all one by one. Let him finish his submission, then we'll hear the victims and all.
Hmm? 291 है ना?
So here he so there is some dues in respect of interior decoration.
That's the claim. My lord, I have annexed the entire statement with regard to my payments made to him. I have paid him till date 12,15,200. My lord, will get that, my lord, at
What is
page.
his due? 9,85,000. 9 lakhs.
No, his due is 2,25,600
100.
because he was paid apparently admittedly some amount.
2 lakh.
And my lord, as per my statement, my lord,
All right.
they can verify it. My lord, I paid them exactly 12,15,200.
So his claim is 9 lakhs and all.
No, 2 lakhs, my lord.
Total
The FIR he says 9,85,000 was
Outstanding
Outstanding amount.
payable.
Outstanding is
একবার দিয়ে 2,85,600 টাকা বাকি।
बाकी है.
Yes.
And you say you already paid
12
over
lakhs. My lord, I have annexed the document.
All right, very good.
My lord,
Yes, the
in-
third case.
My lord, in this case, there's also another point which they said that one vehicle
Yes.
we have kept with us. My lord, I have annexed the RC book from the Vahan side, which shows that the vehicle does not belong to him only. The
Belongs
vehicle
to
which in question which he is saying,
Belongs to, is it with you or not?
no, it is not with me.
All right. Now the third case.
And my lord, in this case, my lord, the brother has been made into the husband, the petitioner number 2,
In the second case.
the second case.
And now the third case.
My third case, my lord, it says that
How this interior decorator is connected with Ananda Datta?
he's a contractor. He was introduced to me by this particular Ananda Datta
Ananda Datta. Okay.
when the relationship was good.
Relationship was good. Yes.
My lord, the third case, my lord, it says that around 5 years back,
Page, FIR page.
my lord, the FIR is at page 296.
সিডি দিয়ে খেলা চলছে ক্যাশে টাকা দিলে 5 বছর পর থেকে রিকভারি হবে। ভাই তুই আমার কাছে যে টাকাটা নিয়েছিস ওটা ফেরত দিয়ে দিস, ওটাও ক্যাশে নিয়েছিস। ঠিক না?
Who is the complainant in this case?
My lord, one person called Mukta Zamal.
Some transfer you assured.
Yes. 5 years back, it is said that I had taken 1.5 lakh.
Or transfer.
Or alleged transfer. After that, he could not get in touch with me for the last 5 years.
But was he transferred?
No.
He was not transferred.
তোর গুলো তো সব আছে, আমার আসলাম পারভেজ কোথায়?
All right. How this man is connected with Ananda Datta?
But I do not know how he is connected, but what I have, there's no document to show,
No document,
nothing to show that
Okay.
that I was involved with him.
Okay.
And all have been lodged in the month of November 2024.
Now,
My lord, so far the interior decorator is concerned, my lord.
you are interior decorator.
I am state for this Pushposhri, my lord, first one.
First one.
In the remaining two, I am for this.
Remaining. Yes.
My lord, so far
Interior.
the interior decorator is concerned, my lord. I have,
Part payment, sir.
that is true, my lord. I have no connection with Ananda Datta.
No,
My
no
lord,
problem with Ananda
I-
Datta.
my lord, now-
Let us say your due was 9,85,000. You've got 7 lakh money. 2,85,000 for that. What criminal case?
But my lord, only thing, my lord, she is kindly considers, my lord, I went there for collection of my money. They restrained me. My lord, she and her husband and others
Are
restrained
they
me,
been
took
detained?
my car, and my lord, I have not given this money. Anyway,
All
my
right.
lord, later I
They
came
say
to
the
know-
car is not yours.
No, my lord, that is my car. I have documents to show that I have entered into a contract with the original owner, but it has not been registered in my name till date, my lord. The registration is not done. My lord, I was using that car and till date I am using that car. Anyway, my lord, the other point is, my lord, I have learned the letter, my lord, which can be corrected by my lord, my learned friends, that she is involved in various scams also, which was not known to me initially. My lord, she is involved in the midday meal scam and all this. Anyway, my lord, these are not connected with
For
me.
that, none of the cases of midday meal scam
My
are
lord,
before
these
us.
are my instructions, my lord. But so far I am concerned,
2,85,000. We will
my lord,
see.
that has not been paid,
We
and
will-
I am not
We will
connected. with
direct
Anand.
cooperation with the investigating agency.
But I am not connected with
With
Anand, my lord.
recovery of vehicle, if any. Yes, Mr. Vitashok Banerjee. Same case, there is on 13th, they have got anticipatory bail. Now 11th, what is the nature of injury?
He is a outpatient, my lord. He has been treated on 12th month.
What is the nature of injury? Simple. All right. Yes, Mr. Bhattacharya.
Matter, my lord.
Transfer matter.
One thing is that petitioner.
After
haven't
5
fully-
years, Mr.
But
Bhattacharya.
I understand, but only have position Indoprastho Ramkrishna Prathamik Vidyalaya Pradhan Shikshika.
Pradhan
That is
Shikshika.
the-
But the transfer is
5 years back, my
no,
lord,
which school?
He is in Mankara Prathamik Vidyalaya. That is
অন্তর্গত অন্য স্কুলে ট্রান্সফার
Vidyalaya.
Which Prathamik Vidyalaya?
Shanwara Prathamik Vidyalaya.
Kanwara. Chal. Prathamik.
অ্যাসিওরেন্স বহরমপুর থানার অন্তর্গত অন্য স্কুলে ট্রান্সফার
Where is this Hanwara school?
That is also under Bohrampur.
Then why will the listen to, if I am a resident of Kolkata, I am in Bohrampur, I can pay money to someone to get transferred to somewhere in Kolkata. I am a person of Bohrampur. I am in a Bohrampur school. Why will I ask for transfer? Chalo, देखो, first one. Petitioner contends he had business transaction, she had business transaction, one petitioner in first,
Yes, my lord.
she had business transaction with one Anando Dotto, who is running
Uh, training center called Asta Nursing College.
who is running a nursing college styled as Asta Nursing College. Full stop. In respect of commercial disputes, Anando Dotto instituted a criminal case, being Bohrampur PS case number
1595 of 2024.
1595 of 2022.
24.
Petitioner has been granted anticipatory bail. This case was earlier or later?
This case was registered first.
The one you are asking for anticipatory?
No, that was registered later.
Present case, thereafter, present case has been registered. Now, in the said case, it was alleged that petitioner had assaulted said Anando Dotto. Only Anando Dotto in the earlier case. In order to implicate the petitioner, in order to falsely implicate the petitioner, Anando Dotto has set up the de facto complainant to lodge similar case against her. Accordingly, he prays for anticipatory bail. Learned lawyer for the state opposed the prayer. He contends that petitioner had assaulted the victim, the de facto complainant on 11/10/2024, and the said incident 24. This incident is independent of the assault on Anando Dotto on 13/10/2024, which is the subject matter of the earlier case. We have considered the materials on record. Admittedly, there are monetary dispute between the petitioner and Anando Dotto. Over this issue, a series of criminal cases have been registered. In one of such case, that is Bohrampur PS case number 1595 dated so and so, petitioner has been granted anticipatory bail. In the present case, it is alleged that petitioner petitioner had assaulted the de facto complainant over the issue of dues payable to Anando Dotto. Possibility of false injury suffered by the de facto complainant is not grievous. Possibility of false implication owing to monetary disputes cannot be ruled out. Accordingly, we are inclined to grant anticipatory bail. 10,000 two sureties. Petitioner shall cooperate with investigation in accordance with law. Next case. Petitioner contends there is a commercial dispute. Petitioner contends de facto complainant is an associate of Anando Dotto, with whom she has monetary disputes. As a result, a series of criminal cases have been instituted. Present case lodged at the behest of the de facto complainant is a species of such false and frivolous litigations. Petitioner has been granted anticipatory bail in other cases. She prays for similar relief. Only one, they pray for similar relief. We have learned lawyer for the de facto complainant contends He is an interior designer and had rendered services to the petitioner. Petitioner has failed and neglected to liquidate the dues. On the other hand, he has detained his vehicle. Learned lawyer for state also.
I have no connection with Anand.
The first of all, petition de facto complainant states he is no way connected with Ananda Dotto. Learned lawyer for the state opposed the prayer. In reply, learned senior counsel contends the contents allegation of detaining the vehicle is out and out false. We have considered the materials on record, including the first information report. In the first information report, it is alleged petitioner, de facto complainant, had undertaken interior decoration in the petitioner's flat. A flat, na? House or flat?
Flat.
In the petitioner's flat. A sum over 9 lakhs 9,85,000. 50,000 was payable to the de facto complainant, out of which 7 lakhs has already been liquidated. Uncontroversial, when de facto complainant went to recover the remaining sum, he was assaulted and his vehicle was detained. In view of the fact, we note that the case has arisen out of a commercial dispute. Substantial amount has already been liquidated. It is unclear whether, apart from the ipse dixit in the FIR, that the de facto complainant's vehicle was detained, there is no other corroborative evidence in support of the allegation. Under such circumstances, we are of the opinion custodial interrogation may not be necessary, but petitioners required to cooperate with the investigation in accordance with law. Same order. Next. We have considered the petitioner contents that the allegation, that there is inordinate delay in lodging first information report, allegation that she had taken money in order to facilitate transfer of de facto complainant to a school within Murshidabad police station or district.
Within Baharampur police station.
Within Baharampur police station is out and out false. He plays for she prays for anticipation. Learned lawyer for state contents, petitioner is the principal, head teacher.
Yes.
Head teacher of a high school in Baharampur.
Prathomik Vidyalaya, primary school.
Of a primary school at Baharampur. At Baharampur. She had induced the de facto complainant, an assistant teacher of Shohorpur, you know?
Shanwara Prathomik Vidyalaya.
Shanwara primary school to facilitate, he had induced to pay money for facilitating his transfer to a school within Baharampur police station. Full stop. We have considered the materials on record. Though allegations are serious, we note that the alleged transaction, we note the transaction is alleged to have taken place in 5 years ago. No contemporaneous document with regard to payment 5 years ago. No contemporaneous complaint was filed either to the police or to any other authorities. De facto complainant also did not make inquiries. Earlier for refund of the money. possibility of false implication. In this backdrop, possibility of false implication cannot be ruled out. Under such circumstances, we are inclined to grant answer. আর cooperation shall cooperate with investigation condition is condition. Next. Ms. Mrityunjay.
My lord, ultimately, my lord, 302, 201, 364 has been, my lord, given in charge sheet, my lord. 12% has been charge sheeted. I am in the serial number 11. My lord, so far, my lord, candid before your lordship, last occasion 1 week back, my lord was pleased to reject the prayer for anticipatory bail of one Ataur. I submit before your lordship, subject to lordship kind sanction. The Ataur is the, my lord, one of the person who abduct me. My lord, kindly consider my role, my lord.
We have considered the materials on record. Petitioner and others had kidnapped the victim and thereafter assaulted him to death. Statements of witnesses implicate the petitioner in the murder. Under such circumstances and in view of gravity of offense, we are not inclined to grant answer.
Yeah.
Next.
My lord, I am on behalf of the petitioner. Petitioner number 1, lordship, the father-in-law. Petitioner number 2, mother-in-law. Petitioner number 3, brother-in-law. 4, lordship, husband.
313, any miscarriage? We have considered the materials on record, allegations of torture.
164, your lordship, they were trying to traffic her to Bangladesh.
All right, our general and omnibus possibility allegation with regard to trafficking appears to be an exaggeration in arising in a exaggeration to implicate the petitioners in a case which arose out of a matrimonial dispute, keeping in mind the no medical report with regard to miscarriage as placed on record. Injury appears to be simple. Under such circumstances, we are inclined to grant answer.
I'm good.
Next.
For the petitioner.
My allegation under section 318, 316, 2, 338, 336. My petition is the mother of the principal accused. My incident happened in 2019, my lord. My lord, civil dispute, my lord, charge sheet submitted. My lord.
We have considered the materials on record. Petitioner is not the principal accused.
My lord, he is the principal accused, my lord. This land belongs to Siddheshwar Ghosh. In the year 1990, there was a transfer deed of gift. That this existing legal heirs, my lord, is challenging that deed. And by dint of that deed, in 2019, mutation has been granted. And my lord, the property has been transferred.
Petitioner contends that we have considered the materials on record. Case arose out of a land dispute. Good stuff. It is contended that mutation was made on the basis of a suspicious deed, which is the subject matter of challenge in a civil court. Be that as it is right, mutation does not create title in the property. In light of the aforesaid circumstances, and as investigation centers around documents which are within the control and custody of investigating agency, we are of the opinion custodial interrogation is not necessary and petitioner may be granted. Next.
I am for the petitioner. The last occasion, your lordship was pleased to direct to principal accused to be surrendered, but he is untraceable, my lord.
We have considered the materials
only
on
one
record.
petition number 2 is the lady.
Principal accused is absconding. Petitioners had abetted the principal accused to kidnap a minor girl. In view of the aforesaid circumstances, we are not inclined.
So far, petition number 2 is correct. 2
rejected. Next. Your son doesn't have love for you. Why should we have love for you?
No, brother, my lord. Principal.
I'm for the petitioner. Allegation is under section 406, 419, and 420. There is not a single allegation against the petitioner. Entire allegation against one Siddhartha Banerjee. He has got anticipatory bail. My lord, kindly come to page 14 of my application.
Mr. Rudra,
কোথায়? So you have purchased the flat?
No, my lord. I am the landlord. I have handed over my
Petitioner is the landlord of the property. Co-accused Siddhartha Banerjee entered into a development agreement and constructed a multi-storied apartment. One Shilpi Mondo, it is alleged, Siddhartha Banerjee in collusion with Shilpi Mondol took loan against one of the flats, but this said loan amount has not been liquidated. Keeping in mind the nature of allegation and the extent of complicity of the petitioner, the landlord of the premises in the transaction in question, we are of the opinion custodial interrogation is not necessary, but petitioner requires to cooperate with investigation, meet investigating officer. Next.
For the petition. In this matter, charge sheet has been submitted against the petitioners under section 498 by 34 of the Indian Penal Code.
allegation against the all is the same, though the allegation is omnibus in nature. Marriage.
Page 12 is the charge sheet, separate charge sheet.
Victim committed suicide by hanging on 8.
Who are these persons?
They are brothers-in-law.
Petitioners are the brothers-in-law of the victim lady, victim wife. Victim committed suicide at the matrimonial home. Allegations against the petitioners are general and omnibus. Investigation is complete and there is no chance of abscondence. Accordingly, we are inclined to grant answer. Next.
My lord, the allegation and dispute took place regarding, my lord, notice of a suspension of a work in a, my lord, jute mill. My lord, what happened, my lord, the first FIR which I annexed.
This nature of injury.
My lord.
You have considered the materials on record. Case arose out of a labor dispute. Injuries are simple. Under such circumstances, we are inclined to grant answer. Next.
Madam, for the petitioner, well, an allegation of cheating, criminal breach of trust, forgery. The complainant is my daughter, and petitioner number 1 is a 71-year-old mother. The petitioner number 2 is the sister, and petitioner number 3 is a
dispute arose out of dispute arose amongst beneficiaries or trustees. Are you trustees?
All are trustees.
Between trustees over management of a trust property. Petitioners are related to each other. Keeping in mind these facts.
Except for petitioner number 4, who is the domestic head.
Who is a domestic?
Petitioner number 1 to 3 are related to the de facto complainant. Keeping in mind this fact, and as the allegations revolve around documents which are in control and custody of the investigating agency, we are of the opinion custodial interrogation is not necessary and petitioners may be granted and suitable.
Grateful, madam.
Trusted, devoted, trusted.
Lordship, the case was started under section 307 and 325 and 34.
Injury.
Lordship,
You have considered the materials on record. Injuries are simple and not life-threatening. Under such circumstances, we are inclined to grant and suitable. Next. Yes, Mr. Kollur Mondol.
If will be taken together.
Yes, my lord.
De facto complaint, my lord, in this matter.
My lord,
For de facto
they pressurized to withdraw the case There is a altercation, first case. Thereafter, subsequently on the next day,
Then
second complaint has been lodged
you are
against me.
pressurizing people to
My lord,
withdraw
kindly
case
see,
against
no, they pressurized me.
Oh, you
They
started
attacked,
a case
yes,
against you.
yes, first
Alright.
case against the.
Then Mr.
My lord, kindly see,
Suit.
my lord, kindly see, there is a,
Where is your first case?
my lord,
Page
my case, page 34,
Got the CD all.
page 34,
As per the.
page 34. My case is page 34. Kindly go through.
This CD is whose?
Your Lordship, this present case.
This is the present case.
And this is the CD of their case.
Their case.
Right up for it.
What is the injury in their case?
Well, only one lord is
That tariki.
there is only cut injury on the finger, my lord. My lord, may I submit, my lord?
Yes.
My lord, 2 years before, my lord, we have been implicated in a murder case, my lord. 37% have been implicated. Out of 20% have been granted antecedent. All other person granted bail, my lord. But till today, we are not allowed to enter our house, my lord. And these petitioners grabbed our land, everything, and cultivated.
Under case, you stay outside. Petitioners submit that
With the help of my lord, we are
they
entering
had
the
lodged
house,
a
my lord,
criminal
and
case
23rd day.
against the de facto complainant. In retaliation, the
This is
present
blood
cases
injury,
have
my
been
lord.
registered. They pray for anticipatory bail. Learned lawyer for de facto complainant submit that petitioners have prevented him
By
and
these
his
petitioners, my
associate
lord.
petitioners have prevented him and his associates from entering the village. In view of the aforesaid submission, we directed production of the case diary in respect of the criminal case being that is Rotua PS case number 571/24, registered by the petitioners against
570.
570.
571
570.
70. So the 71 pardon.
So, my lord,
This is the
570.
present.
571.
We have filed, my lord, 571, my lord.
And this is their case.
Oh,
My lord, 6% have been, my lord, injured, my lord.
570. Where is the injury in 570?
41, 44 years.
570. Roto appears 570/24 dated 23/10/2024. Full stop. We directed case in addition to the case diary in the present case. We from the materials on record and in light of the submission made at the bar, we note de facto complainant have been charged with murder. De facto complainant, your client,
No.
your
My friend.
associates,
Well, associates.
associates of the de facto complainant were charged, were implicated in a murder case. Over this issue, tension prevails in the locality. On the fateful day, there was fight between the parties. A criminal case was lodged by the petitioners on 23/10/2024. Criminal case was lodged by the petitioners against the de facto complainant and his associates. On the next day, cases have been registered against them. In light of the aforesaid facts, we have examined the medical papers. We have also examined the medical papers. In the background of the aforesaid facts, we are of the opinion custodial interrogation for progress of investigation may not be necessary. But petitioners required to cooperate with investigation in accordance with law. Petitioners shall report to investigating officer once in a week until further orders. Apart from the ladies,
Well, specific allegation against
Grateful.
Shadikul, my lord. Kindly see, my lord. And we are not allowed, my lord, till today, last 2 years, my lord. But a civil writ petition also filed, my lord.
de facto police authorities shall ensure
My lord.
that the de facto complainant is permitted and his witnesses are permitted to reside at their residence
My lord.
without disturbance.
My lord.
Thank you.
Next.
Same.
এটা একটু দেখো না লেডি অ্যাকিউজ গুলো দেখে নেবে।
Allegation under section 42406, my lord, FIR lodged after 13 years from the incident. It is 2021 to 11 incident, my lord, and lodged in 2024.
We have considered the materials on record. There is inordinate delay. Incident arose out of a commercial dispute. There is inordinate delay in lodging first information report. Under such circumstances, we are of the opinion custodial interrogation is not necessary and petitioners may be granted and suitable subject to condition. Petitioner shall meet investigating officer once in a week and further. Next.
Lordship, I'm praying for not to take. For the state.
What is the allegation?
Against this petitioners, they forced the signature of the de facto complainant and transferred one property in their name. So she is the housewife and the petitioner, one is the father-in-law and two is the sister-in-law. They have outstated the de facto complainant after her husband's death and transferred few properties in their name. This is the allegation.
Properties. De facto complainant's property.
Husband's.
Husband's property.
Husband.
It transferred in what form? By a
Their
registered
name, by a deed, registered deed.
during the lifetime of the husband.
Receive the case there is.
All right, not today. Not today.
Petition also.
Not today. Not today.
Grateful, Lordship.
Next.
Hello, I'm for the petitioner, my lord. Well, 180 is the primary allegation, my lord. What?
Injury.
My lord.
To pay the EMI, committed suicide.
No, mother has taken loan from petitioner number 4.
That note is there.
Only 164 of the neighbor, but you will kindly give.
Petitioner number 2 had advanced loan to the mother of the deceased.
4, my lord.
Petitioner number 4 had advanced loan to mother of the deceased. They were to repay the loan in installments. They failed to repay the loan. Over this issue, there was a dispute. Full stop. Deceased committed suicide. She did not leave behind any suicide note, but statement of witnesses show that petitioners had misbehaved as her mother, as she had failed to repay one of the installments. It is in this backdrop whether conduct of the petitioners in demanding installment would constitute whether the conduct of the petitioner in abusing the deceased for not paying installment would constitute abatement to suicide requires to be assessed at the appropriate stage of the proceeding. Keeping in mind these facts, we are of the opinion custodial interrogation is not necessary and petitioner may be granted answer.
Deeply.
Next.
My lord, I'm for the petitioner. My lord, I'm for the petitioner. My lord, the sections are 126 to 115 to
Yes.
109 85. My
Who
lord,
are you? Who are you?
I am the father-in-law and the
Father-in-law,
mother-in-law.
any allegation? We have considered the materials on record. Petitioner is the father-in-law of the victim wife. Allegations of torture, general and omnibus. Keeping in mind these facts, we are of the opinion custodial interrogation is not necessary and petitioner may be granted anticipatory bail.
Grateful, my lord.
CD just oh, no CD is there. All right, we'll take it up after 5 minutes. Huh? Just check out. If there's any specific allegation, tell us. Otherwise, this order will remain. Other matters will take up after.
Your husband is on bail.
Husband had returned.
And within my lord, 1 year of the marriage, the incident. My lord,
Grateful.
my lord, mother-in-law and father-in-law are the petitioners. Well,
Made, please, your lordship. Lordship, I am for the lordship corresponding section in IPCR 448, 323, 307.
Yes, your lordship. There is
Case
some
counter case.
injuring your lordship.
I am highly obliged.
May it please, your lordship. Now, the allegation under section 105 of the BNS corresponding to 304 part 2. Now, the petitioner is the secretary of a rehabilitation center. Now, the son of the complainant was a drug addict. He was admitted to this rehabilitation center for his drug addiction problem. He was admitted for 9 months and subsequently he expired due to chest diseases. Now, 304 part 2 case has been registered against him.
Page 7 is the PM report and the bottom respective cardiomyopathy participating. Just read. Page 7.
Secretary.
Owner.
Center. Known as the Shivayan Nesha Mukti Kendra.
Cardiomyopathy.
MD Brigade.
Three, my lord, appearing for the petitioner. My lord, a dispute arose over construction extending the cornice of the window of an under construction building between two neighbors. Now, a case was started. My lord, no, my lord. The accused persons in that case were granted anticipatory bail by this honorable court. Subsequently, their wives have been implicated that they are threatening, and one morning they
This is earlier case and So the status of the earlier case.
এটা my lord এটা আগের order. Great.
Well, I'm for the petition. But this is second application, my lord. Make please, your lordship. I'm assisted by Mr. Banerjee.
It's my duty to point out, my lord, that the petitioners, the complaint are related to the Saddle Hotel. This is a fresh matter, but it's my duty to point out to you.
This is of recent vintage of July 2024.
I'm just indicating, I mean, it's my duty to. No. No. My lord, the dispute is by and between the brothers. The brother now is deceased. So this case is.
Well, may I only initially there was a dispute between the petitioner number 1 and 2 and 3 and the widow. At that point of time, the de facto complainant was on the side of the uncles. Well, this has nothing to do with that issue.
Only I'm.
I know your lordship has released it only because it's just before the vacation. May I only humbly request the learned additional public prosecutor to see that the application is not rendered. The
Non-bailable sections are 118(2) and 109 of the BNS, my lord. The allegation is that, my lord, the son of the de facto complainant. Out of the house at about 11 in the night, my lord, for buying. My lord, at that time, my lord, it is.
Statements are there. Kindly speak, your lordship.
My lord,
Kindly see page number 62, your lordship.
my lord, can you see, my lord, FIR also, my lord? Due to, my lord, political rivalry, my lord, have been implicated.
Fracture on the medial.
My lord, the allegation is that fist and blows. And my lord, thereafter, my lord, by lathi, my lord. And chased with a knife. My lord, deep.
Not 3, my lord.
Petitioner number 3, my lord.
Father-in-law, my lord, petitioner number 2. Father-in-law. Deeply.
So item number 38 can it be taken at 2 p.m. Just now I have received the CD. Yes, no.
Tomorrow.
That's the app for the petition. Corresponding section 326, 308, 379.
Their specific allegation means all three of them, your lordship.
Kindly see
Just
the
one victim statement at page number 32.
मतलब 2017 marriage, 2019 first 498, 2022 another 498, and मतलब 2024 another 490 along with 376D. Now मतलब against these petitioners, all are sisters-in-law. Against them charge sheet has been submitted under section 498 and 34. Earlier 498 acquitted. मतलब against them charge sheet has been submitted. That is why allow me to leave. Grant me leave.
Well, 223, 115, 117, and 109, my lord. My lord, what has happened, my lord? The person, my lord, 223 is 188 of the BNS. Fully. No.
Disobedience of the order of the.
My lord, there was a 144 proceedings. My lord, now, my lord, this person, this.
Injury report is there. 144, sorry.
Mal.
The case is under the purview of NDPS Act, my lord. My name transferred from the statement. The charge sheet filed, my lord.
My lord, this is the second application they have not mentioned in their petition. I have placed the last order.
আরেকটা কেস আছে এই কেসে সিলেকশন
রাহুল 18টা কয়েন নিচ্ছে না লিস্টটা যে এফআইআর লিস্টটা
Outline.
Madam, for the petitioner, my
What are
lord.
you having for the state, my lord?
On a petitioner being an astrologer, my lord, was asked to do.
Yes, my lord.
Kindly see, kindly see, my lord, I have annexed all
Not
documents.
astrologer, my lord. He is doing black magic.
No. My lord, all WhatsApp chatting with the client I have annexed, your lordship file. My lord, just kindly find
1,50,000 and 12 ornaments.
But all thing has been given. With respect, my lord, kindly
No,
see-
not return.
My lord, let me place my
Acha,
case.
acha, ठीक है.
Kindly come to page 23 once. With respect to son, my lord, he has contacted me. Whatever service I have done, she was satisfied. Now, with respect to husband, my lord, kindly just see page 25. That was refused by me, and thereafter refusal, everything has been started. Just page 25, my lord. Our next every WhatsApp chatting. Kindly see what was the request and what is my reply there. And there, my lord, page 25. My lord. With respect to sir, whatever duty I have done, he was satisfied.
This is his document.
Kindly see page 20. This is the WhatsApp chatting. Kindly see my reply. And thereafter, my lord, several calls I have denied. Missed call, your lordship will find our next. The documents payment receipt I have annexed. Even I have made complaint against them.
आपका नाम भी लिख दो रातुल का नाम लिख दो রাতুল বিশ্বাস বিশ্বাস পিটিশনার নেই লিখে হচ্ছে রাতুল নেই রাতুল देखिए ना मैं लोग
My lord.
Yes, that is it.
No. If you like.
Obligement.
I never made.
Madam, for the petitioner. What allegation under 419, 420, 406, 413, 414, 120B. Well, the raid was conducted. But few persons, young boys and girls, they were running call center. Lordship will kindly understand. My lord, 164 statements were recorded. Nobody has named me. They have named the other person who was arrested. Subsequently, 3 persons has been granted bail. Charge sheet has been submitted. Nobody, not a single iota of witness was against me.
My lord, sees the statement of the victim.
Asked you, tell us, see this thing.
My lord, he's the brother of the principal accused. From their house, the SIM cards were recovered. The victim says that the phones, everything was handed over to this petitioner. He's been absconding for 2 years.
Petitioner is the petitioner contents. He is no way connected with the illegal business or what was the business? They were
Call center, insurance policies.
fraud. Petitioner was not involved in the cyber fraud. He has been falsely implicated. He prays for answerable and a lawyer for the state opposed the prayer. We have considered the materials on record. A cyber fraud. A cyber fraud a cyber fraud, an organized criminal activity in the form of cyber fraud was carried out, was being carried on in the residence of the petitioner and his brother. His brother is the principal accused. Complicity of the petitioner, there are materials to show complicity of the petitioner in the crime. He had absconded during investigation, and during investigation under such circumstances, we are not inclined to grant action. Next.
Great.
Make please, Your Lordship. But an abandoned Bolero pickup van was found in a market area. The marketplace, the locals, my lord, informed the police. Police, my lord, conducted a search, and my lord, 2,200 bottles of fentanyl was found inside the Bolero pickup van.
375 bottles of fentanyl was found. My lord, this is the person, is the prime principal accused, my lord, who is dealing with this. My lord, kindly see the two
Investigation going on.
Yes.
We have considered the materials on record. Over 10,000 bottles of fentanyl syrup containing codeine phosphate was recovered from a Bolero vehicle. Investigation has revealed the involvement of the petitioner in the transportation of the narcotics substance.
My lord, I was only found, my lord, talking to the driver of the vehicle. This was my
Investigation is in progress, and custodial interrogation for custodial interrogation for unraveling further evidence is necessary, keeping in mind the gravity of the offense and statutory restriction of 37 of NDPS Act. We are not inclined to grant that. Next.
I'm for the petitioner, Lordship. Proceed to accurate statement, nothing recovered from the petitioner, Lordship.
Rejected. We have considered the materials on record. Charge sheet filed?
No, not filed.
We have considered the materials on record. BSF personnel arrest recovered
300 bottles fired. 300 bottles fired.
It's 300
bottles fired.
300 bottles of fair deal, 300 bottles of fair drill, cup syrup containing codeine phosphate from co-accused traveling in a motorcycle. Full stop. Complicity of petitioner has transpired during investigation. Custodial interrogation for progress of investigation is necessary under such circumstances, and in view of statutory restriction and 37 of NDPS Act, we are not inclined to grant that. Next.
My lord, service is not complete. I am humbly praying, let state also serve.
Mr. Babuli.
My lord.
Officer in charge shall notify the victim with regard to the pendency of the proceeding and a right to legal representation 1 week after vacation. Next.
1 week after vacation.
Next.
I am for the petitioner, my lord. The case under section 341, 323, 325, 307, and 34 of the Indian Penal Code, my lord. Subsequently, charges submitted under
CDM just praying for not today.
Not today.
Yes, sir. Tomorrow. Much obliged.
Lordship, I have served updated till 21st December. 2 co-accused granted anticipated bail by
My
your
lord,
lordship.
it's not same footing, my lord. When the girl was being rescued by the parents of the victim girl, my lord, they were being
For 52, I appear for the petitioner, my lord.
My
My lord,
lord, still, my lord, I do not have the CDS.
my lord, allegations of kidnapping, my lord. My lord, 3 of the accused, my lord, has been granted bail. My lord, this will reflect from this order. And my lord, other 2, my lord, on instruction, I'm submitting, my lord, there are all total 6 persons. Other 2, my lord, on instruction, I'm submitting, my lord, they have been granted bail. 3 has been granted bail by.
You will also get bail.
Lord.
You will also get bail. Produce the case diary, huh? Case diary be produced 1 week after vacation. Victim has been recovered. Keeping in mind this fact, we direct petitioner shall not be arrested in connection with this case for a period of 2 weeks or until further order.
Great.
Next.
My lord, service not complete.
Though, my lord, the charge sheet has been submitted under section, my lord, 75 BNS, that is, my lord, 354A only. Others are sub-billable section.
Let us produce the case diary. Officer in charge shall notify the victim with regard to pendency and a right to legal representation 1 week after vacation.
Grateful, man.
Next.
Case is under section 109, 118, 126, section
My lord,
5, section
the injuries seems to be grievous, subject to your lordship. This person is the principal assailant. My lord, there is a sharp cut injury in the right side of the cheek. This person is the principal assailant. Other person has been injured.
Injury.
Page 14 is the injury.
Injury report.
Page 14, my lord.
We have considered the materials on record, including heard learned counsel for the parties. We have considered the materials on record. We have also considered the injury report. Injuries do not appear to be life-threatening. Under such circumstances, we are inclined to grant ancillary bail subject to condition, meet investigating officer once in a week on further office.
Okay.
Next.
My lord, for the petitioner. Allegation under section 118 and 109 of the BNS Act. My lord.
My lord, injury on injury is, my lord, grievous, my lord.
How did the incident?
2% sustained injury, my lord.
How incident occurred?
My lord, the present petitioners and others, my lord, assaulted the father and.
We have considered the materials on record. Incident occurred. Heard learned counsel for the parties of it, huh? We have considered materials on record. Incident occurred over a land dispute. Injury. Though one of the injury is grievous, incident does not appear to be a premeditated one and had occurred on the spur of the moment. Keeping in mind these facts, we are inclined to grant answer.
Grateful, my lord. Grateful.
May I please allow? So, there is a commercial transaction between the defector complainant and the present petitioner. Manat, your lordship was standing on the same podium as granted bail.
Business stands in the name of wives. They have been granted anticipatory
All right,
bail.
we have
This petitioner
considered
is
the
the husband,
materials
41 and not complied.
We have considered the materials on record. Incident occurred. Case was registered. Case has been registered. Has arisen out of a commercial dispute. co-accused have been granted anticipatory bail. Under such circumstances, we extend similar relief to the petitioner and meet investigating officer once in a week or further.
I'm obliged, my lord.
Next.
May please the lordship, my lord. 498 307 as per the my lord IPC 9085 109 of the BNS 34 of the Diabetes Prohibition Act has been
Yes,
before your
injury.
lordship.
My lord, kindly see this. This is the statement of the eyewitness neighbors, my lord. Husband within 1 year of marriage.
No, not 1 year. They have a child, my lord. How 1 year? Huh? They have a child, my lord.
The
As per
child accused.
1 year marriage how? 1.5 বছরের বাচ্চা বলেছে।
No, no.
Medical report?
My lord, medical is not there.
We have considered the materials on record, allegations of torture.
My lord, may I submit only one thing? My lord, in the lower court rejection, there has been stated that they perusing the medical documents, but my lord,
Produce the medical documents.
my lord,
Medical papers, if any, be produced before this court. Matter will appear on 6th of January. Pretty full stop.
My lord, in the meantime, my lord.
Nothing. Next.
Free fight between neighbors on the score of grazing of goat in the compound.
Yes, but then what is the
325,
consequence of
326,
the free
307.
What is the consequence of the free fight?
Page 23 to 26 is the injury report.
You have been granted anticipatory bail by the learned court below annexure A, page 7, and annexure B, page 8 of my application.
Injured statement, my lord. I have folded the page, my lord.
We have seen that.
Charge sheet submitted.
Who have been granted anticipatory bail?
My lord, Samidul Mondol alias Shamu Sheikh, by page 7. Rantu Mondol, Rentu Sheikh Mondol, Firoz Mondol, and Sentu Mondol. Sentu, Shomi, Firoz, and Samiul.
Shentu has been granted. Firoz has been granted. All right.
Sentu granted.
Consider the materials on record.
Sentu was granted bail.
Firoz,
Same footing. We have considered the materials on record. It is alleged petitioner and others had assaulted victim, resulting in fracture injury. However, co-accused have been granted PRS bail. Petitioner stands on the same footing and is entitled to similar
Great fit, Lord.
bail by the sessions judge.
बोल दिए
Bail. Sentu got bail.
Yes, my lord. Sentu got sessions থেকে bail পেয়েছে, not anti bail.
बिल पेज यही तो बिल पेज
You will
Page
get
7.
bail.
page 7 yes annexure A, page 7 bill the fourth application is 438 my lord the first line says 438
What? 483.
Judicial custody.
483.
483.
it says 438 my lord annexure A, page first line my lord
Please see annexure C. Annexure A is of an 80-year-old man.
Yes.
We have considered the materials on record. Statement of the injured implicate the petitioners in the assault. Victim suffered fracture injuries. Petitioners do not stand on the same footing with co-accused who have been granted anticipatory bail. owing to their old age and gender. Under such circumstances, we are not inclined to grant and
Deputy.
next.
My bad. May I please, your lordship, my lord. 326, 307, my lord. Charge sheet filed against 33%, my lord. Free fight is there. Kindly consider the role of the present two petitioner before your lordship, my lord.
Injury. Bomb blast is there, injury report is there.
33%, my lord, implicated.
Consider the materials on record. Petitioners are named by eyewitnesses as members of the group who throw bombs. Medical report shows victim suffered bomb blast injuries. Under such circumstances, we are not inclined to grant it.
Great.
Next.
I'm for the petitioner, my lord. 447, 325, 326, 307, 34. Lordship, charge sheet submitted. Civil dispute all.
Lord, the injury report says grievous. Third petitioner hit with haswa on the head. The second petitioner appears to be a lady, and the third petitioner hit with lathi. The lordship will kindly peruse the injury report.
Consider the materials on record.
1 and 2, lordship, their own.
Number 3 hit the victim with a hesua on the head. He suffered fracture injuries. Keeping in mind the primary role played by petitioner number 3 in the assault, we are not.
As also
Petitioner number 2 and 1 also. I don't know.
Lord, 2 and 1 with iron rod.
Oh. Yeah, 35 pages.
Petitioner number 3 with hasua, and the other 2 with iron rod. Leg fractured, my lord. Lordship will kindly peruse.
Petitioners assaulted the victim with iron rod and hasua. He suffered various injuries, including fracture. In view of the aforesaid facts and gravity of offense, we are not inclined to grant bail.
Obliged, lord.
ঠিক আছে, লিখছো তো ঠিক। Next.
May I please, your lordship, my application, my lord. My lord, 498, 307, my lord, IPC, 85, 109 of the BNS, 3 and 4 dowry provision. 5 years back, my lord, the marriage took place. Charge sheet has already been filed here, my lord. My lord, where the
in-law is the father-in-law and petitioner number 1 is the husband, my lord. But the injury
Consider the materials on record. Incident arose out of a matrimonial dispute. Petitioners are the parents-in-law of the victim.
My lord. Petition number 2 is the husband.
Husband and father-in-law, my lord.
All right, get it up. Injury report shows slight injury. Investigation is complete. Under such circumstances, we are inclined to grant it.
Grateful, my lord.
Next.
I am for the petition, lordship. Lordship, section 135, 138 of the Electricity Act, lordship.
What is the
City is not disabled.
bill for unmetered?
Final order of assessment, lordship, 1,56,720.
Who is appearing with his which?
I am for the state. CD is not.
CSC, this is CSC.
Miss A. Research.
I will intimate her.
Please inform of tomorrow we are keeping.
Lordship.
Next. Officer in charge.
I'm for the petitioner, my lord. I'm for the petitioner, my lord. The allegations are under section 318, subsection 4, 316, subsection 2, 351, subsection 3 of Bharatiya Nyaya Samhita. My lord, the main allegation is extortion under the assurance of providing employment. I am the driver. The prime accused is already on bail, my lord. I have annexed the order, my lord. There is no specific allegation against me. The allegations have been clubbed together, alleging several other accused persons. My lord, I am just the driver. No specific allegation, my lord.
Your certificate where it is reflecting that the petitioner has taken a loan of 25 lakhs from the complainant and therefore he did not return.
Loan, what? How loan will become a criminal case? Non-payment of loan? Is there any criminal case against them? How do you know?
The memo which was sent to me, there are no antecedents.
He is saying that these petitioners have taken money from large number of people. Ask the investigating officer to be present. Investigating officer is directed to be personally present on the adjourned date. Matter will appear on 7th of January.
My lord, some protection, my lord.
Nothing. Next.
Petitioner section under 126(2), my lord, 177, 172, 1091, my lord. My lord, there are 15, my lord, accused person, out of whom only 8 are on bail, my lord. I am the principal accused got statutory bail till date charge sheet not submitted.
Materials on record. Petitioner is not the principal accused. Co-accused have been granted anticipatory bail. Petitioner is entitled to similar relief.
Grateful, my lord.
Next.
My lord, I am for the petitioner. My lord, the allegation under section, my lord, 420 and my lord, 406 of the Indian Penal Code. My lord, the de facto complainant is the nephew of this petitioner. My lord, the petitioner had given an accommodation since 2015 in his house. My lord, thereafter the de facto complainant wanted to purchase the property. My lord, I sold the property, my lord, in respect of 11 decimals of land. And my lord, out of 21, my lord, 10 decimals of land I had given to the government for the welfare of the child. That was done in the year 2021. Now in 2024, the nephew came and my lord stated that there was an agreement to give him the entire property. My lord, the pay,
Page 54.
We have considered the materials on yes. Let us see the FIR. Page 34. Page 34.
My lord, kindly.
my lord,
FIR
34 and my lord, this de facto complainants.
Kindly see the 2 schedules of the deed, my lord. The first deed, my lord, will find at page, first deed document, at page 54, my lord. এটা কি 11 ডেসিমেল বিক্রি করেছে আউট অফ 20, তাই তো? আর এটা তো 10 থেকে the rest did not, my lord, told me this my lord.
My lord, the rest property, my lord, handed over to the local authorities for the development.
So what is the deed?
First deed, my lord, we find at page 54. That is of in the year 2021.
54.
Yes. Kindly see the statement, my lord, how much portion was sold.
What is the reciter? Huh. Where is this? A? How much is being sold?
11 decimals.
11 days.
Out of 21.
11 days.
Now kindly to come to page 39. This is the deed, my lord, which was in favor of contract.
Huh.
Here he sold, my lord, 10 days.
No, not sold, my lord. That was gifted.
No, but there is a transaction which you have got.
39.
39.
কি হলো বিক্রি করেছে গভর্নমেন্টকে যেটা দিয়েছিল ওটা বিক্রি করেছে
হ্যাঁ
কি আশ্চর্য টাকা দেখা গিফট করেছে
প্রথমে লেখা আছে কত টাকা দিয়ে বিক্রি করছে
হ্যাঁ 5,000 মূল্য এত has it been registered?
both these are registered.
Huh?
Both are registered.
Both are registered.
কিন্তু টাকা নিয়ে আসে
So there is a gift deed for 10 decimals. And then
that is 21. First, my lord, he transfers 11 to this complainant. This 10, he transferred to the concert of it.
Very good.
And now the complainant comes and say, why you have not transferred me that 10 decimal of land?
So why should he? We have considered the materials on record. Petitioner had transferred, had sold 11 decimals of land to the de facto complainant against valuable consideration. De facto complainant contends that the entire land was to be transferred to him. This is denied and disputed by the petitioner. This issue requires to be thrashed out before the appropriate forum in accordance with law. However, custodial interrogation for progress of investigation is not necessary. Allowed. Next.
My lord, I am for the petitioner. The petitioners are the father-in-law, mother-in-law, and the married sister-in-law. My lord, after 9 years of marriage, the victim committed suicide. My lord, initially the case was started under 103 BNS, what is 302. Subsequently, my lord, it culminated into a charge sheet into 306.
Victim wife,
statement of the minor.
wife committed suicide.
No, I am
at the matrimonial.
Husband is in custody. We are the
Victim wife committed suicide at the matrimonial home. Petitioners are the in-laws of the victim lady and pray for anticipatory bail. And a lawyer for the state opposes the prayer. We have considered the materials on record, including the statement of the minor son who alleges her mother was murdered.
No, my lord, case of 3.
However, the postmortem report shows death is due to hanging. Due to hanging, which is predominantly suicidal. In view of the aforesaid dichotomy, which improbabilizes the allegation of homicide, we are and the extent of involvement of the petitioner in the crime, we are inclined to grant answer. Next.
My lord, item number 71, I pray leave to appear over the video conference. Mr. Zishan is appearing physically. My lord, a 41-year-old widower from Delhi meets a 40-year-old divorcee in Calcutta on the online matrimonial site. They hit it off, they meet a few times. The allegation is that we have exchanged money for various things. She lent me some money to clear some dues. Thereafter, her daughters have found out about this relationship and they have put their foot down. Now the relationship is sundered And she says that I've taken her money. 420, 406 is the result.
I'm appearing on behalf of the de facto complainant. My lord, kindly see this from a monetary transaction by stating himself as a divorcee, my lord. 5 lakh rupees has been taken by this.
So why you gave 5 lakh rupees?
My lord, initially he has stated that they will go for a relationship.
So that is why he will give 5 lakhs.
Document.
When
Kindly
petitioner submits that there was a romantic relationship between the parties. Subsequently, the relationship soured and they have been falsely implicated. And she has been falsely implicated. She prays for anticipatory bail.
He, my lord, I'm the.
He has been falsely implicated. He prays for anticipatory bail. Learned lawyer for de facto complainant. Contents petitioner promised to marry her. As a result, she handed over cash and she credited cash to his account, which he has misappropriated. Learned lawyer for de facto state also opposed the prayer. We have considered the materials on record. It statements of witnesses, including the victim, show a romantic relationship developed between two adult persons. In this backdrop, de facto complainant had credited monies to the petitioner. Whether the transfer of funds was prompted through dishonest inducement may be assessed at the appropriate stage of the proceeding. However, custodial interrogation is not necessary, and the process of criminal law cannot be used for recovery of outstanding dues. Accordingly, we are inclined to grant anticipatory bail subject to conditions. Petitioner shall meet the investigating officer once in a week.
Man, I should do so. Deeply obliged. Grateful.
Next.
Mr. 72, I am for the petitioner, Lordship. Lordship, this is an application for extension of time to surrender, Lordship.
Petitioner was who could not surrender?
The petitioner,
Huh?
only one petitioner, Lordship.
Huh? Only one accused is there, or there are two accused?
72.
72, there are two accused, two petitioners.
Rajbahar Sheikh, Lordship.
Petitioner number 1 was unable to appear before the. This is in July 2023. For 1 year, you have not surrendered. Why?
I was under impression that the pair has been rejected.
Then you go and surrender. We are not going to extend time.
So that's why.
Order of anticipatory bail was passed in July 2023. We are not convinced with the explanation given by petitioner number 1 applicant with regard to the reasons why he was unable to appear, why he did not appear and pray for regular bail within the time stipulated in the order. In such view of the matter, application for extension of the time to appear and pray for regular bail is rejected. Next.
I beg to appear for the petition. My
দেখেছেন?
75 দেখেছেন? We- 75 million, I am for the petitioner. It is a, no, this is under the column of application, but the application has already been disposed of on 17th.
Yes, so
Because as such, I have my client engaged Mr. Milan Mukherjee. Kindly let it be fixed for after vacation.
after
Second,
after
Under the heading, under the heading.
under the heading,
whatever heading, we will take it up. All right. Please be ready to assist us.
কাগজ কাগজ আছে? হ্যাঁ দিয়ে দিচ্ছি।
My lord, I appear for the petitioner, my lord. This is my petition for relaxation of conditions in an anticipatory bail, which was granted in respect of an FIR for non-payment of money for goods applied by a third party to another third party, my lord. My lord, my client is presently suffering from neurological diseases, my lord. My lord, I have annexed the medical documents at page 74. He's 57 years old. My lord, you will kindly see the anti-bail order once. It is at page 11.
Nothing as an anti-bail order.
I'm sorry, my lord. Anticipatory bail, my lord.
This who is for state?
My lord, the state had appeared last time and sought adjournment.
You please get a report by tomorrow. All right, tomorrow. Positively.
Grateful, my lord.
My lord, I am for the petitioners, my lord. My lord, the petitioners are unable to furnish the bail bond, your lordship.
Petitioners are unable to furnish.
Yes, your lordship, there is a.
Order not annexed.
My lord, there is a mistake, your lordship. Our clerk Dada has filed this without annexing the order dated 14th August 2024.
The same order has been rejected.
It was dismissed, my lord. I'll file this. I'll annex this order, your lordship. Kindly grant me to file a supplementary affidavit.
All right, what additional material you have lodged?
But the petitioner number 1 is a day labor, your lordship.
Where
And
have you made that statement? Where have you made that statement? That will not do, madam.
my lordship, I'll file a fresh.
Leave to file supplementary affidavit placing on record additional materials.
Grateful, lordship.
Adjourned 1 week after vacation.
Grateful, lordship.
Yes, next.
78, my lord, I am appealing for the appellant. It's a legal aid matter. My lord, it's an arguable case. My lord, it has appeared as a bail in connection with appeal.
What is arguable?
Your lordship,
No.
hearing it. My lord, late for the time being, my lord, bail in connection.
No arguable case. Nothing is arguable.
My lord, why? My lord, the DC is missing on 13/6/2014.
Yes. But then,
And
Mr.
my lord,
Mondal,
recovery on, my
what
lord,
about
kindly,
PW
yes.
11 and 12?
Yes, my lord, there is, my lord, so-called eyewitness. Why, my lord, you lordship, my lord, don't believe it on the basis of, my lord, eyewitness, because they are the co-villagers. My
All
lord,
right, after vacation.
yes, my lord,
You make your submission.
yes. That's why.
Because the difficulty is, I'm telling you, PW 9, 10, 11, 12. These are
9,
the
10, my lord, I have, yes,
circumstances.
I have
Other circumstances
I have
are
already
not that
said
important.
earlier, 9, 10, 11 and 12.
13th of June,
Yes,
she goes missing.
Yes.
Body is recovered on 15th of June.
Yes.
All right, FIR is registered.
Identification on, my lord, identification on the dead body on 16/6. 16/6. No, my lord, complaint lodged.
Right.
Thereafter, my lord, FIR lodged on 2nd July 2014.
Correct, correct.
Yes. My lord,
The son identifies on 16th.
yes.
Which son is 4.
Yes.
He identifies on
Yes.
16th.
Yes, my lord.
And then
Because, my lord, no complaint. Subsequently,
one
yes.
second, and then the brothers identify on 2nd.
Yes.
And the FIR is registered. The allegation is what? That on the leading statement on 24th of July, a shirt is recovered with a boulder on your showing. That is one circumstance.
27. Yes.
Now, who identifies this shirt as your shirt?
My lord, the accused himself, my lord.
The accused himself, identification is an identification.
Identification, so far identification is concerned.
A shirt with a boulder.
Yes.
Is there any evidence that the shirt belonged to you?
Seizure list witness PW7 and PW8.
But nobody says that. Please, this is
That was
understand, Mr. Mondal.
that was not, my lord.
What is there? He indicates on his showing a boulder with a shirt is recovered. Nobody says that that is his shirt. Now, therefore, the main problem is PW 9, 10, 11 and 12.
PW7.
Matlab PW 9 and 10 matlab last seen together, and PW 11 and 12 is the eyewitness.
PW 7.
Yes, Your Lordship. Page 31 is the Lordship. Actually, Your Lordship, in this matter, Sumant is appearing, but on the last occasion there was no Your Lordship.
You appear. You appear.
PW7, page 31.
8 of that.
4 lines. Your Lordship.
Yes.
Page 31.
He identified that this was that shirt.
He identified.
Not accused.
Not accused, sir.
He identified the shirt.
Shirt.
But does it belong to the accused?
It is not.
No.
On his showing, so it is not the accused. On his showing, a boulder with a shirt is.
Boulder and shirt. Sky blue
Now,
shirt.
9, 10, 11, 12. Mr. Mondal, all right, we'll give you an opportunity to
Yes.
improbabilize 9, 10, 11, and 12.
Yes.
If these two circumstances are believed, Mr. Mondal, then section 27 recovery at your behest, it becomes clinching evidence.
Yes.
PW5 also, who is the son of the deceased.
4.
PW4, Your Lordship. And the PW5 is the father. He states regarding quarrel, and he says that they were sleeping together in the courtyard.
That is all right. Nobody disputes they are staying together as husband and wife. Nobody disputes that there is the girl went missing. First thing is that when she was identified, Khan says she was identified on that day. The next day, 15th, 16th, he has identified. No FIR was registered till PW1 identifies. There may be some delay because of institutional reasons and all that. The thing is, what is the motive? What is the dispute? Some say she wanted to convert to Christianity, over which there was a dispute.
Because the appellant's family had already converted, so she also wanted to convert.
So how can there be a dispute then? If husband had already converted.
No, husband, he did not convert. The family member.
Husband has converted. Entire family member has already converted. It was.
So that is one reason. There is another reason given, that there is some demand of money, which again is not really very convincing. Then he is seen coming out of near the spot, and 11-12 sees him throwing something in the pond. These are the two important witnesses. Please indicate. We ask you to prepare a note and tell us why we should not believe 9, 10, 11, 12.
11 and 12 is the eyewitness.
Are 11, 12 eyewitness? 9, 10.
9, 10 is the last thing together.
Seeing him
come out from the house.
Then চলো after vacation heard
Yes,
Mr.
yes.
told arguable. Horen Murmu Bikash.
Lordship, for item number 80, Mr. Shomujit Das Mahapatra is appearing for the appellant. My lord, he is out of station. My lord, kindly fix it after vacation.
After vacation. You are for?
No, my lord.
Who is for state? What is this case? That confession?
No, my lord, this is a case, my lord, FIR was lodged by the mother of the deceased son. The PW2 was the purported eyewitness, PW1 is the purported eyewitness. And my lord, FIR was lodged against 22 persons.
Ah. Here the one person should get an acquittal. Shama should get an acquittal.
My lord,
who is appearing for Horen and Shama? Amita, who is appearing for Horen and Shama?
for
Because one state though,
appellant is Jindal.
then appellant, Sushanto Sardar. Now Bikash assaulted. Everyone says Bikash assaulted.
But my lord, there was no purported eyewitness was there, but there was no other
Yeah,
independent
wife
witness.
witness is not there.
My lord, no other
The mother
independent.
is there. The wife is there.
My lord,
She said three witnesses are there.
my lord, PW2 was at the time of offense, PW2 was unconscious.
PW2, but PW1 was there.
And my lord,
PW6 is there. 1 and 6 are there.
My lord,
So,
kindly fix it
so
after
you
vacation.
see Bikash entering. Horen is named in the FIR as someone who is present, and when he is entering, he says Horenda wants to talk. Right? They don't open the a gate. But Amita, how do you sustain Sushanto Sardar? Sushanto is not named in the FIR. And the allegation against Sushanto of assault is only by PW6. No, sorry, by PW11, who is a reported witness. Shamapodo Bikash assaulted by PW6. Bikash assaulted PW1. Where is Sushanto assaulting? We understand Horen and Bikash, but Sushanto doesn't appear to be implicated. It on mere suspicion has been implicated. Yes.
I'm for the 79, my lord. I'm for the appellant.
Who is for 78?
My lord, 79 and 80 are connected.
Oh, 79, you are there.
And 70 for 80,
We
Mr.
are
Shomujit
in
Das
agreement with you that no case is made out against Sushanto.
Sushanto.
Horen is there.
Horen, my lord.
Horen was very much present.
No, my lord.
Yes, sir.
The name of my lord.
Please see the FIR. The name is taken. When they open, Horen also enters. Examine PW1 in light of FIR. See the FIR?
25 to 26%.
Correct, 25 to 26%, but Horen there first. There is a voice who says to PW2, I am Bikash, Horen sent us for some discussion.
Horen sent us. Yes.
Correct. For heaven's sake, open your paper book. Horen sent us. Then they open and they see all these persons, including Horen Murmu, son of Baburam, present. That is the FIR.
এটা কে তুমি? আমার একটা স্লিপ করে দাও কল্যাণ কুমার ভার্সেস আইটেম 79 কল্যাণ কুমার ভট্টাচার্য। কল্যাণ কুমার ভট্টাচার্য। এ ডবল ই করে ভট্টাচার্য জি 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 ডবল for the appellant for the item number 79. এটাও তো ওখানে রয়েছে না। Bill number 79.
করে দিচ্ছি। Died.
What the die?
Then
কোনো এভিডেন্স আছে? বিকাশের এগেনস্ট এসছে হরেন, ওই বিকাশের স্টেটমেন্ট হরেন আসছেন, সুশান্তর এগেনস্টে কোনো এভিডেন্সই নেই। এবার তুমি অ্যান্ড আদার্স যদি না হলো এগুলি অ্যাক্টিভেটেড হলে আমি 34 কিবোর্ড সাসপেন্ড করব। মতো বলা উচিত দ্যাট ইউ অ্যান্ড আননোন আদার্স, যেখানে এফআইআর এতজনের নাম আছে। I Miss God will keep it tomorrow. There are 2 or 3 problems. One is if you see Sushanto, how do we implicate Sushanto? Not named in FIR. 1, 2, and 6. They are the persons who were present. They do not attribute any overt act to Sushanto. For the first time in court, they say that he is present at the spot. If he was present, he would have been named in the FIR. So his presence at the spot also is doubtful. So far as Horen is concerned, although FIR says names Horen as someone is present, but if you read the FIR as a whole, Vikas said Horen sent us. And in evidence also, Horen sent us. Now,
he was not the assailant.
How do we implicate Horen on the co-accused statement? Now, if we acquit these two, how do we convict Bikash under 34? There is only one evidence that Shamapodo also assaulted. Right? PW6. But in the evidence, they are saying Horen was present.
Horen's presence a few
He says he's there. And then Bikash and Shamapodo hit my husband. Horen, you will see Horen in PW6 says Horenda, Bikash, Sushanto, Shamapodo knocked at the door. They are saying they knocked at the door, but in the FIR it is said that Horen sent them. And PW1 also says Horen sent them. So we keep it tomorrow. Our basic thing is Sushanto we find is very weak piece of evidence against Sushanto.
Lordship, Mr. Somajit Dasmapatra is out of station, my lord.
Maybe out of
My lord,
station.
kindly fix it on 2nd January.
No way, no way,
My lord, my lord.
no way. You must be ready tomorrow. We'll finish this up.
My lord, kindly fix it on 2nd January. 2nd January will.
All that second. Yes, that's good. What we will do tomorrow? We'll finish this up. We could have finished it.
Lordship, 2nd January.
Tomorrow.
second.
Arey, our senior is not there.
Yes, my lord.
Okay.
My lord, before writing, my lord, item number 31, your lordship has recorded the injury was on forearm. However, my lord, the injury was on forehead. I should have pointed that out, your lordship. I apologize.
31 not to do. Please. Tell the state lawyer. You are the state.
Yes, your lordship.
Tell the petitioner.
Petitioner.
All right, Miss God. He's asking second. We'll keep it on second. Second will dispose it of.
Yes, my lord.
Because you have no option.
My lord.
Because goes.
Then
So far as Horen, we can give them the benefit of doubt. Sushanto to certainly. Horen also, whether Horen was present, it is doubtful.
Someone saw him or not, that is.
The FIR, they make an impression Horen also enter. But in evidence PW1 gives impression that and P1 and 6 again says Horen was present. So that please examine whether Horen at all was present. If Horen was not present, then Horen gets the benefit. Sushanto certainly gets the benefit. All right.